I guess one of the first questions I had for you, and you mentioned there's several stages where a case could get settled. Mediations, arbitrations might get you some resolution there if you don't just resolve it yourself. But do you have a sense for the number of cases you take versus the number that actually end up having to go to trial or all the way through a trial?
Yeah, I mean, I think, again, this gets back to the point of the advancement of mediations, arbitrations being a lot more common today than they were years ago. Really, probably a smaller percentage of cases that actually make it all the way to a jury trial. I mean, certainly that happens. And when it does happen, it's more time for the lawyer, more time for the client. Going through a trial is not it's not something that everybody does every day. So it's not necessarily a comfortable thing for clients to go through, but generally speaking, it's a really smaller percentage of cases that go to trial. Now, with that being said, medical malpractice cases, you're generally taking it all the way to the steps of the courthouse, even if it does get resolved without a trial. So you're still going through, as the lawyer, as the client, you're still going through the process of the case, which I think we'll get into in a little bit more detail than just, a case getting resolved at an early stage. Generally speaking, these cases, it's going to require all the workup and getting it to the steps of the courthouse if it does get resolved without, a jury trial.